President Idi Amin versus Museveni and the debate about trying civilians in military court. Maybe the reason why Museveni wants to prosecute civilians in military courts is because he is saying to himself that President Idi Amin did it, therefore I must also do it. So let's get to the historical beginning. Some are claiming that it is Idi Amin who started the legal precedence of military courts in Uganda, and they think that Amin's special tribunal is the same thing as the general court-martial. The Amin government was established as a military government, but even he understood that this did not mean that military law applied to Ugandan civilians. In fact, that's the reason why President Amin had to create a special tribunal that is completely separate from the court-martial. The Justice Odokis, the legal minds that advised President Amin, they recommended the special tribunal away from the general court-martial. Here's the context. President Idi Amin's military tribunals were created following the 1972 invasion by rebels from Tanzania. After failing at the front lines, the rebels dispersed and embarked on heinous abductions and murders of Ugandan elites around the country. The special tribunal of the Amin government tried these terrorists, who even abducted the late Chief Justice Benchuanuka, Makerere University Vice Chancellor Frank Kalimuzo, Ankole Prince Patrick Ruhinda, and many others who were abducted and murdered following that invasion, never to be seen alive again. Every Ugandan who was there at the time, or those who have heard from their grandparents, all know that this is the time the terrorists infiltrated the country and started to commit heinous crimes that they would then run to the international media to blame on Amin so as to demonize him. This is fact. This is also the very period when stories that Amin was a cannibal started coming out in the international media as part of their global disinformation campaign against President Idi Amin. Ugandans knew it, and they knew that it was all lies. Many of the terrorists were arrested. Some, like Museveni, were lucky to escape arrest in Mbale on January 22, 1972, after he was found driving the very vehicle whose registration number UUU171 had been reported by eyewitnesses of Benchuanuka's abduction. Museveni's fellow murderers were arrested that day and tried the following month at the Special Military Tribunal under Ugandan criminal law, not military law. Basically, the Amin Special Military Tribunal was a legal replication of the High Court, not an extension of the General Court-Martial of the military. At the end of the trials, the innocent were freed and those guilty of the murders and disappearances were sent to the firing squad in public and their crimes read out to the people of Uganda prior to their lawful sentence being served in the presence of their victims' relatives. The military tribunal was created by presidential decree, which is a legal instrument, so as to expeditiously handle this dangerous security situation that the military was addressing at the time. And the tribunal was provided with the adequate legal framework and powers to handle the serious crimes it tried. Another thing that many today do not know is that the special tribunal was temporary. It came, served its purpose, and was disbanded twice, 73 and 77. Now, the composition of this special military tribunal was also only military in the presiding officer, who was the only soldier in the tribunal. Everyone else, from the prosecutor, the lawyers, and the clerks, were all civilians from the High Court. This tribunal was mostly created to provide justice expeditiously on terrorists caught as prisoners in the battlefield or caught abducting and murdering prominent Ugandans. I believe there is even a documentary of President Idi Amin urging his government to work in that direction so that justice is served and not delayed for the victims' families. The Nuremberg trials of German officials after World War II were in the same spirit. The Gacaca courts in Rwanda or the trials in Sierra Leone were of the same nature of addressing a specific conflict. Special tribunals are an international standard, despite what many want to smear the Amin government about out of ignorance. His special tribunal had a presiding officer who actually only signed the rulings and sentences that were all recommended to him by civilian legal assistants based on the laws of Uganda. So the tribunal was only military in name and the presiding officer. And anyone can inquire from the last Chief Justice Batka Turebe and the Amama Mbabazis, who served in President Idi Amin's judicature as young legal assistants. Now here is a simple example to demonstrate why civilians cannot be tried in a military court. In a civilian environment, an officer could ask a civilian to carry for him a box, and the civilian can say, "Go carry it yourself, man." But under military law, a soldier who says that to his superior would immediately be charged with insubordination and taken to military police, which is actually exclusively the police of the military. Another area that the Supreme Court needs to look into, because military police is now engaging in civilian law and order issues. From military police cells, the insubordinate soldier would then be sent to the General Court-Martial, which would try the soldier and punish him accordingly. But that same court can't punish civilians for insubordination because civilians commit no offense when they refuse to carry the box. Civilians have more expansive rights than serving soldiers. The bottom line here is that civilians being court-martialed under military law is totally unhinged. Military courts exist all over the world for military discipline and order in the army. The only function under military law, these courts only function under military law and the military code of conduct, which are only for serving military members. A retired officer like Besigye is by law a civilian who left the army, and therefore he cannot be tried by the court-martial properly. As the unique nature of military service needs to maintain discipline in the armed forces, the Uganda Supreme Court ruling is wrong in dismantling the general court-martial completely. However, the Supreme Court is 100% right in barring any trial of civilians in such a court. This is actually the only distinction that MPs must address. What the Supreme Court ruling also means is that Museveni should compensate all the civilians he has tried under his illegality, including compensating the civilian victims of the general court-martial in Karamoja, where many were tried, jailed, and sometimes even shot in firing squad since the time Museveni's wife was Minister of Karamoja. The number of people dead, injured, and who disappeared in that Karamoja operation must be put on the table in Parliament by the UPDF. But many Ugandans don't know that. They don't know that even under today's Supreme Court ruling, Amin's special military tribunal would pass the test of being lawful, as it was actually different, was not a general court-martial, was legally given powers of the High Court to try civilians, and did not actually operate under military law. Otherwise, it would have also been illegal. Most of all, it was a temporary thing. Therefore, ignorance of the difference between the general court-martial and the special tribunal could be what is disturbing Museveni. But then it dawned on me that he has never undergone proper military officer training in his life. His rank of general, therefore, could be described as a tin pot general, where he has never been educated on the purpose of the general court-martial or the purpose of the military police. Yet Amin, for example, was an officer who graduated from the famous Sandhurst Royal Military Academy in UK and understood it all. So it is funny to see Museveni fighting relentlessly like a foot soldier for something that can't work, and he doesn't understand that it can't work, and all his people whom he sent to military academies and therefore might know that it doesn't work are instead fearing because they haven't found a way to tell him that what he wants is actually idiotic. Meanwhile, the people of Uganda had two Bazungu Europeans talking in the recorded evidence of Dr. Besigye's trial. Where are those Bazungus and what was their role? Were they sent to frame an innocent Besigye, or were they really plotting regime change together? Whatever it was, the two Europeans should appear in court because they are either state witnesses in a plot to frame Besigye, or they are accomplices whose voices are in the evidence they recorded of themselves talking to Dr. Besigye. The people of Uganda want to know the truth, and it is the duty of the state, the Director of Public Prosecution, and the Attorney General to ensure pristine justice is served in this case. Dr. Besigye suffering while others are left to walk scot-free is an injustice, of course. As for President Museveni, I recommend that he go back to professionalizing first himself and the army, and ensuring that sober, competent officers run the army in a manner that is ideologically sound to international standards of military administration. Officers who can then advise him bravely and professionally, just like the Justice Odokis advised Field Marshal President Idi Amin Dada, even though they were not military officers. But they even drafted for him all his presidential decrees so that everything was accurate and legally sound under both Ugandan law and international legal instruments. And despite everything that all the dumb and clueless smearmongers say about President Idi Amin. Thank you.